You signed it on your first day and you barely read it. And now you have a better offer on the table and your old employer is waving that non-compete in your face like it is a prison sentence. But here's what most people do not realize. That piece of paper is not automatically enforceable. But Florida is also one of the toughest states in the country for employees on this issue. And in 2025, it got tougher. In this video, I will explain how to fight a Florida non-compete agreement in 2026. And by the end of this video, you will learn where these agreements are vulnerable, the two kinds of non-competes Florida now has, and the one mistake that destroys a case before it even starts. All right, let's dive into this one. I'm Santiago Cueto, board-certified international business law expert and best-selling author based right here in Miami, Florida. I have spent years helping business owners and professionals navigate exactly these kinds of high-stake contract fights, and I'm going to walk you through this the way I walk a client through it. One quick note before we dive in. This video is general education. It is not legal advice for your specific situation. Your contract is unique, and you should have a Florida attorney review your actual document. All right, now let's get back into it. First, the big picture. There is a rumor going around that needs to die. A couple of years ago, the federal government tried to ban almost all non-competes across the country. A lot of people heard that and assumed they were free. Well, here's the reality. The federal rule was stuck down in court and the FTC later dropped its appeal. Now, the bottom line for you is simple. There is no federal ban. In Florida, your non-compete lives or dies under state law. And that statute is Florida Statute 532.335. And Florida leans employer friendly. The law does not start from the idea that non-competes are bad. It starts from the idea that courts will enforce them when they are reasonable. That is your battlefield. Now here's the part almost no video explains correctly. As of 2025, Florida has two kinds of non-competes. The kind you have changes everything. The first is the standard non-compete under Statute 542.335, and this covers most workers. Under this framework, a restriction of 6 months or less is presumed reasonable. Anything longer than 2 years is presumed unreasonable. That 2-year line is your friend. The second one is a new one. It is called the Choice Act, and it took effect on July 1st of 2025. This one is aggressive. It lets employers enforce a non-compete for up to 4 years, but it only applies to high earners. The threshold is roughly twice the average wage in your county, and that figures vary by county and updates over time, so verify the current numbers for your county. Now, when you earn under that line, the Choice Act likely does not touch you. And that is good news because the Choice Act is far harder to fight. So why is it harder? Well, because under the Choice Act, the law presumes the agreement is enforceable. The burden shifts to you to prove it should not be. Courts are even directed to issue injunctions unless you clear a high bar of evidence. So the first move in hiding your non-compete is figuring out which world you are in. A good attorney can tell you in just one reading. Now, quick pause here. If this is already clearing things up for you, do me a favor and hit that like button and subscribe to this channel. I break down Florida business and employment law every week because you deserve to understand how the law affects you before you learn the hard way. All right, back to it. Now, here's the part you came for. Where do these agreements actually break? Well, the first weak point is no legitimate interest. Florida will not enforce a non-compete just to stop ordinary competition. The employer has to prove a real protectable interest. That means trade secrets, substantial customer relationships, confidential information, or specialized training. And when you had none of that, the employer may have nothing to protect. No legitimate interest means no enforcement. Now, the second weak point is overbreadth. This is the most common one. Too long, too wide geographically, or it bans you from work you never even performed. When a non-compete says you cannot work anywhere in the country for 5 years in any related role, that is overreach. But here's the catch, and I will not sugarcoat it. Florida courts use what's called blue penciling. When your non-compete is too broad, the judge often rewrites it to be narrower instead of just throwing it out. So proving it's too broad can still leave you with a tighter court-approved restriction. A partial win can still keep you on the sidelines. Now, the third weak point is the employer's own breach. Did they fail to pay you what they owed you? Unpaid commissions, bonuses, wages? In some cases, the employer's breach becomes your defense. And the fourth one applies only to choice agreements. That law requires specific steps. written notice of your right to a lawyer, a review period at least 7 days before signing, a written acknowledgement. Now, when the employer skips a required step, that is potential opening. Now, treat these steps as a checklist to confirm with your attorney against the current statute, not as a legal certainty. So what do you actually do? Well, there are 5 moves here. Move 1, get the actual document, not your memory of it, the signed copy. Every word matters here. Move 2, do not quit and do not start the new job yet. This is the mistake I promised you at the top. People resign, they start competing, and then they call a lawyer. But by then, they have already handed the employer a violation to point at. Get advice before you make your move. Move 3, talk to a Florida employment attorney. Many offer a free or low-cost first consultation. They will tell you which world you are in and how strong your position really is. I cannot tell you your odds in a video. Only a lawyer reading your contract can. Here's move 4. Think about negotiation, not just litigation. Many of these end with a letter, not a courtroom. A good attorney may negotiate a release, a narrower scope, or a carve-out for your specific new role. That is faster and cheaper than a war. Move 5. Document everything. What you had access to, what you did not, any money you are owed, the full timeline, facts, wins, cases. And let me give you the honest truth. Florida is hard for employees here. The 2025 changes made it harder for high earners. But hard is not impossible. Non-competes get defeated, narrowed, and negotiated away every single day, especially the lazy copy and paste over broad ones. So don't panic. Don't assume you are trapped. Get the document, stay put, and get a real Florida attorney to read it before you do anything at all. Now, if this video helped you understand what's at stake, hit that like button, subscribe to this channel. I put out content like this regularly because Florida professionals and business owners deserve to know how the law affects them before they learn the hard way. I'm Santiago Cueto, your Florida business attorney. Be sure to watch more of my videos right here.